Social media is buzzing with claims that Quadajah Johnson's murder case is going to be dismissed because the state charged her with 6 counts of first degree murder, and because, according to some people, those charges won't stick because it was self defense.
When people do the most, I do the analysis. Let's go.
Today, I'm breaking down exactly what these 6 counts are, why there are 6 of them, what the state would have to prove, and why Quadajah Johnson being out on pretrial release doesn't mean this case has slowed down or that the charges are disappearing. Because as of now, this case is still moving forward, full steam ahead, and the next status hearing is scheduled for August 11th. Let's start with the biggest misconception. When people hear 6 counts of first degree murder, they may assume the state has to prove all 6 counts beyond a reasonable doubt, or that the entire case is going to fall apart. That's not how these charges work. 6 counts might look like the state is piling on when you only view it as a number, but that assumption misunderstands what the 6 counts actually mean. Quadajah Johnson is not accused of killing 6 people, and she's not accused of committing 6 separate shootings. But legally, the structure is designed to reflect multiple theories and escalating firearm allegations connected to one homicide, not 6 unrelated charges that's just manufactured out of thin air. The 6 counts are different legal theories and firearm allegations arising from one homicide, the death of Romika Blackman. Illinois law allows first degree murder to be charged under different theories. The 2 theories cited in Quadajah Johnson's true bill are this. First, the state can allege that Quadajah Johnson intended to kill, intended to cause great bodily harm, or knew that her actions would cause death. And second, the state can allege that Quadajah Johnson knew her actions created a strong probability of death or great bodily harm. Those are different ways that the state can attempt to establish the required mental state of Quadajah Johnson for first degree murder. And then attached to those murder theories are different firearm allegations. So the state appears to be presenting multiple legal pathways, if you will, involving the same alleged killing. The first 3 counts are based on the first legal theory under Illinois' first degree murder statute. Count number 1 alleges murder under the intent to kill or cause great bodily harm theory with the allegation that Quadajah Johnson was armed with a firearm. This firearm allegation is the lowest of the 3 firearm levels that are listed in the true bill. It means that regardless of whether Quadajah Johnson just happened to be pregnant on September 8th, she intended to kill or cause great bodily harm to Romika Blackman by arming herself with a firearm. Count number 2 uses that same underlying murder theory, but it adds on the allegation that Quadajah personally discharged the firearm. The discharge itself is more specific than just saying that she was armed. This means that regardless of whether Quadajah Johnson had the weapon on her person or whether she went and retrieved it from her car, as alleged by eyewitnesses at the crime scene, Quadajah Johnson not only brought a gun, armed herself with a gun, she fired the weapon at Romika Blackman. She only needed to fire once for this charge to stick, but Quadajah fired her weapon several times. Count number 3. Again, it uses the same underlying murder theory, but this time it adds on the allegation that Quadajah Johnson personally discharged the firearm and that the firearm discharge caused Romika Blackman's death. And listen, this is the most serious firearm allegation in this group. So counts 1 through 3 are not 3 separate murders. They are essentially the same underlying murder theory charged with 3 escalating firearm allegations. Armed with the firearm, personally discharging the firearm, and that discharge caused death. So I ask you this: was Quadajah Johnson armed with a firearm? Yes. In fact, it was a 9mm weapon with hollow point bullets. She didn't just reach into her jacket pocket and say, "Oh, wow, look, here's a gun." No, she intentionally armed herself with a firearm. Did Quadajah personally discharge her firearm? Well, by her own admission, she surely did. And did Quadajah personally discharge her firearm and the discharge of her weapon caused Ramika Blackman to die? Yes, and again, yes. Romika Blackman received two fatal gunshot wounds, one to her leg, the largest bone, the femur, and another to her face, fired at close enough range by Quadajah Johnson that Quadajah's hands and her clothing and even her shoes were covered with Romika's blood. The cause of death was not asphyxiation by Carlos Smith's chokehold. So I just went over the first murder theory and the 3 counts of murder with intent associated with the first theory. But before I move on to the other 3 counts, I want you to ask yourself, which one of those 3 counts, counts 1 through 3, are likely to get dropped before or even during the murder trial? I'll wait. Nah, I'm not going to wait. Let's move on. Counts 4 through 6 are based on the second theory cited in the indictment. Under this theory, the state alleges that Quadajah Johnson knew her actions created a strong possibility of death or great bodily harm. Again, the state paired that murder theory with the 3 firearm allegations. In count number 4, the state alleges the second murder theory while armed with the firearm. In count number 5, the state alleges the same murder theory but adds the fact that Quadajah Johnson personally discharged the firearm. And finally, in count number 6, the state alleges the same murder theory but adds that Quadajah Johnson personally discharged the firearm and that the discharge approximately caused Romika Blackman's death. Once again, these are not allegations of 3 separate killings. They are different legal allegations connected to the same homicide. The first murder theory says that Quadajah Johnson killed Ramika with a gun. The second murder theory says that Quadajah knew Ramika could or would die from those gunshots. At a minimum, she knew that if Ramika somehow survived the gunshots, that she would be maimed and possibly become wheelchair bound. I'm talking about great bodily harm. Again, I want you to ask yourself, regardless of whether Quadajah Johnson wanted Ramika to die, do you believe that Quadajah knew that Ramika could or would die by those multiple gunshot wounds? Now, tell me which one of these 3 counts do you think the prosecution's going to drop or be unable to prove beyond a reasonable doubt? Now, this is where the social media rumors really fall apart. The state doesn't have to prove every one of the 6 counts in order for there to be a first-degree murder conviction. The state has to prove the elements of at least one legally sufficient first-degree murder theory beyond a reasonable doubt. That means that the jury could reject some theories or allegations and still find Quadajah Johnson guilty under another count if the state proves that count beyond a reasonable doubt. For example, the jury could conclude that the state didn't prove one particular theory, but that they did prove another. Or the jury could find that one firearm allegation wasn't established while finding that another one was. The counts give the prosecution alternative legal routes to argue the same alleged homicide. That's why the claim, if one of the 6 charges don't stick, the whole case is going to have to be dismissed. It's not just misleading, it's factually wrong. Because that's not how alternative counts work. These counts arise from the same act that occurred on September 8th and the same victim, Romika Blackman. Illinois law is not going to allow multiple convictions and punishments for the same physical act. There's a one act, one crime rule that prohibits that. So, to be clear, the charges won't stick is not a legal argument, but people are entitled to believe that Quadajah Johnson acted in self defense. And they're entitled to believe that the state can't prove its case. And the defense has every right to challenge the evidence. And they will. They can question witnesses, they can argue self defense, and they will. And they can argue that the state failed to prove guilt beyond a reasonable doubt, and they will. But saying that the charges won't stick because there are six of them, that's not making a sound legal argument. The number of counts don't automatically make the indictment defective or mean that the case is going to get dismissed. Dismissed why? Dismissed where? Another point that we can't overlook is that these are not minor charges. First degree murder is already one of the most serious charges under Illinois law. And Quadajah Johnson is currently out on pretrial release, literally fighting for her life. The firearm allegations shown in the True Bill, they have major sentencing consequences if the state obtains a conviction and those enhancements are proven. The three levels, they correspond to allegations involving being armed with a firearm, personally discharging a firearm, and personally discharging a firearm where the discharge caused death. Those allegations can carry significant additional sentencing consequences under Illinois law. So even though the six counts involved one alleged murder, this is still an extremely high stakes case. And the most serious counts appear to be count number 3 and count number 6, because those are the counts alleging that Quadajah Johnson personally discharged a firearm and that the discharge caused Ramika Blackman's death. I don't typically like to address rumors, but some of the rumors involving this case are beyond speculation. They're beyond imagination, so I felt compelled to address them today. And having said that, there's another rumor that needs to be addressed. Some people are talking about Quadajah's release as though the criminal case is now on hold, or as though the state has quietly backed away from prosecuting her. That's not what pretrial release means. Quadajah is out of custody on pretrial release while the case continues. By nature of the word itself, pretrial means before trial. So for the record, Quadajah Johnson is still facing 6 counts of first-degree murder. She's still required to comply with the conditions that's been imposed by the court. Judge Clancy said you better be back in that house before those streetlights come on. And the criminal case against her is still moving through the court process as it did while she was locked up at the Cook County Jail. The next status hearing for this case is scheduled for August 11th. It's going to be another procedural checkpoint where the court's going to review the progress of the case. They're going to address discovery. They're going to discuss pending matters, set deadlines, or determine what needs to happen next. It's not a trial date, but setting a trial date could be discussed now that the detention issue has been resolved. But it's not. And I repeat, it is not a hearing where charges are going to be dismissed. Now that we understand why there are 6 counts, we also need to talk about the part of this indictment that could have enormous consequences if there is a conviction: the firearm sentencing enhancements. In Illinois, people sometimes refer to these enhancements as the 15, 20, 25 to life law. This is where the language in Quadajah Johnson's 6 counts become extremely important. Because under Illinois law, when a person is convicted of a qualifying felony, including first-degree murder, the use of a firearm can trigger additional mandatory prison time. The amount of time, though, is going to depend on how the firearm was allegedly used. The first level, 15 years. If the offense was committed while the person was armed with a firearm, the law requires 15 years to be added on to the prison sentence that's imposed for the underlying offense. And the underlying offense in this case is murder. The second level is 20 years. If the person personally discharged the firearm during the commission of the offense, the law requires 20 years to be tacked on to the underlying prison sentence. And the third and most serious level is 25 years to natural life. If the person personally discharged their firearm and that discharge caused great bodily harm, permanent disability, permanent disfigurement, or death, the law requires an additional sentence of 25 years or up to natural life. And that last point is critical. These are not simply the total sentences by themselves. They are enhancements that are added on to the sentence for the underlying offense. So if Quadajah is found guilty and she's sentenced to 25 years in prison, an additional 25 years is going to have to be added on to natural life. And with first degree murder, there's no good time off. She's going to have to do all of that time. If there is some kind of a plea, second degree murder or manslaughter does not require the mandatory firearm enhancements, but the judge could still add them on. Then it will be at his discretion. So if Quadajah Johnson gets convicted of first degree murder and the applicable firearm allegation is proven, the firearm enhancement is gonna substantially increase the total sentence. That's why the firearm language in Quadajah's true bill is not just legal wording that can be ignored. The indictment separates the firearm allegations into three levels. We've talked about them: armed with the firearm, personally discharging a firearm, and personally discharging a firearm causing death. Those allegations correspond to the 15, 20, and 25 years to natural life enhancement, and that's the structure under Illinois law. Now, I want to be precise here. These enhancements do not mean that Quadajah has already received an additional 15 or 20 or 25 years. Obviously, she hasn't been convicted. She's still awaiting trial. The state has to prove its case beyond a reasonable doubt, and Quadajah remains presumed innocent. But if there is a conviction and the applicable firearm allegation is established, the sentencing consequences will be extremely serious. And that's why counts 3 and 6 are significant, because they allege that the firearm discharge by Quadajah Johnson caused Ramika Blackman's death. In other words, the prosecution, they're preserving multiple legal theories that could potentially support a conviction based on the same alleged conduct. And that's not automatically improper. Prosecutors, they can charge different theories where the evidence might support more than one legal route to proving the offense. And because the state has to prove guilt beyond a reasonable doubt, prosecutors might include alternative theories rather than just gamble everything on one interpretation of the evidence. But there is an important distinction. Multiple counts don't automatically equal multiple punishments. The court has to address how the convictions will merge or are treated under Illinois law. So the state does not have to prove all 6 counts to obtain a first degree murder conviction against Quadajah Johnson. If the state proves one legally sufficient first degree murder theory beyond a reasonable doubt and proves the firearm allegation that applies here, the case does not automatically fail just because another count was not proven. At the same time, the presence of 6 counts don't guarantee a conviction. The indictment, it's an accusation, it's not proof. The defense can challenge the evidence. They can challenge the state's theory, and they will. They can argue self-defense, and they will. They can cross-examine witnesses and argue that the state failed to meet its burden, and they will. But ultimately, the question is this: can the state prove the required elements of at least one first-degree murder theory beyond a reasonable doubt while overcoming the self-defense argument presented at trial. That's the issue that the court process is eventually going to have to resolve. So when people say, oh, they done stacked up 6 charges because they know ain't none of them going to stick, that's just speculation. What the 6-count indictment shows us is that the state is pursuing multiple legal theories and multiple firearm allegations arising from the same homicide. In other words, the prosecution has found multiple ways to get at a single conviction. These allegations carry enormous consequences if the state can obtain a conviction. Quadajah's release on pretrial conditions did not erase any of these charges. And it certainly didn't end the prosecution. And we know it didn't eliminate the potential sentencing consequences. The case is still moving forward, and Quadajah Johnson's due back in court on August 11th. So, you guys, here's the bottom line. Quadajah Johnson is facing 6 counts of first-degree murder arising from one homicide. The 6 counts reflect 2 different first-degree murder theories. Each one is paired with 3 escalating firearm allegations. The state does not have to prove all 6 counts for a conviction to occur. And if the state proves the element of one legally sufficient first-degree murder count beyond a reasonable doubt and it overcomes any applicable defense, that can support a conviction. At the same time, Quadajah Johnson is presumed innocent, and the state still carries the burden of proving guilt beyond a reasonable doubt. The grand jury indictment, it's not a conviction, and the charges, they're just allegations at this point. And the defense is going to have the opportunity to challenge the state's evidence and present its own legal argument. And they will. The claim that this case is going to be dismissed because 6 charges won't stick, well, that's just trash. This case is moving forward and is moving toward trial. And until the judge dismisses the case, the state drops the charges, or a jury reaches a verdict, the legal process is still very much alive. I don't see the state having any problems proving the 6 counts against Quadajah Johnson. Their biggest hurdle, though, will be proving that it was not self-defense.
It doesn't matter. You shot somebody, nigga. What the fuck wrong with you?
If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave me a comment down below letting me know your thoughts. Do you believe the multiple theories strengthen the state's case, or do you believe the defense is going to be able to defeat them? Meet me in the comments. We can continue the conversation there.